actually is, what it's not, also what a forensic psychologist does. There's a lot of misconceptions about the work of a forensic psychologist, the background of a forensic psychologist, the areas of work. We're going to explore that in this module video, so hopefully you'll have a better understanding also about what are the qualifications, what are the programs required, these types of questions. So we're looking at what is forensic psychology. One thing that we want to differentiate, I think, is between forensic psychology and forensic science. Many people believe that they're the same. They believe forensic psychologists arrive at the crime scene, survey the area, and then they identify the clues they need to catch the criminal. And this is CSI and lots of other great shows over the years, or movies that have shown criminal investigations and forensic folks at work. It leads us to believe that this is what a forensic psychologist does, where the truth is that they don't do so much of this, not as much as we thought. If you look at Catching the Bad Guys here, it says, actually we've moved to criminal investigative analysis. It's just a better term that we call it today. But a recent survey by psychologists and psychiatrists showed that 31.5% were knowledgeable about criminal profiling, 16.3 had training in it, but only 10.9 rather had generated a criminal profile in their careers. So not many forensic psychologists actually do criminal profiling, although very interesting area of the work. So forensic psychologists are not just biologists or chemists, and are rarely crime scene investigators or law enforcement officers. It might sound kind of odd, but they're just psychologists. They study human behavior, and the main thing they do is try to apply the principles to assist the legal system. That is their main focus and emphasis. The word forensic originated from the Latin word forensis, which was the forum used to locate or describe the location in ancient Rome. This forum was the location where citizens of that day resolved disputes, kind of like modern-day courtrooms today. They conducted the business of the day. Role of the forensic psychologist, as I just mentioned a minute ago, it's to assist the legal system. That is the main role. So, what is the definition of forensic psychology? As it says here, there's much debate in the field itself about the precise meaning. You'll hear lots of different definitions and ideas. Any application of practice of clinical psychology, broadly speaking, to the legal system, but more specifically, we're talking about the clinical psychology and its intersection with the law. Clinical practice of psychology focuses on assessment, treatment of individuals within the legal context, and includes concepts like psychopathy, insanity, risk assessment, personal injury, civil commitment, etc. What is the difference between a psychologist and psychiatrist? There's a few. They're differently trained. Number one, a psychiatrist is a medical doctor and focuses on medication and patient care, where a psychologist has more training in research and providing psychological assessments. They do psychological evaluations quite routinely, which kind of makes them better suited for the field of forensic psychology. And nowadays you'll have more psychologists that are in the business of doing this work rather than psychiatrists. Both can work there, and traditionally psychiatrists were the ones that had the authority, but nowadays you're seeing the psychologists do more work in forensic psychology. When talking about the history of forensic psychology, I'll give you a quick rundown. The clinical practice of forensic psychology is often credited to these first couple people, Leitner Whitmer and William Healy. Both were pioneers in this. Whitmer, pronouncing his name correctly, taught courses in psychology of crime in the early 1900s, where William Healy was provided Chicago juvenile psychopathic institute that he opened in 1909, which was a place where they basically focused on juveniles more than anything. State versus Driver, 1921, psychologists testified as an expert witness on juvenile delinquency. It was later overturned, but it was the first time we had a psychologist rather than a psychiatrist or any other expert in the field testify. And then Jenkins versus United States in 1962. This was a big case. Psychological testimony could be admitted to determine criminal responsibility by a psychologist, and this opened up the floodgates. This led to a boom in the 1960s and 70s of psychologists becoming much more heavily used as expert witness in forensic cases, as opposed to a medical doctor or a psychiatrist, which, like I said before, were the ones that were considered the experts prior to this. So what are the major areas of forensic psychology? Well, they work in criminal law, and they also work in civil law. In criminal law, we're focusing on acts against society. It's the government that takes the responsibility for pursuing criminal matters through law enforcement officers and prosecutors. So the focus of criminal law is really to punish the offenders in order to maintain societal sense of justice and also deter crime. Examples, the murder that may have occurred last night or the mugging downtown are considered violations of criminal law because we as a society do not consider these behaviors appropriate and consider violations of criminal law an offense against any one of us. So it's the state or the government that acts upon society as the prosecution and files criminal charges against an offender when it believes an individual has violated criminal law, rather. Mens rea, that other right here, mens rea, is a principle of criminal responsibility that relates to an individual's mental state. Mens rea, or what we call guilty mind, means that an individual has committed an unlawful act willfully or purposefully. So it goes to suggest culpability, blameworthiness of a defendant. So psychologists are sometimes rendered, actually, when we're looking at this, it's when we're looking at insanity cases or issues of insanity. Psychologists will get involved to make a judgment or to make an expert testify or their opinion, rather, on the state of a person's mind, if they should be held responsible and felt like that we can hold up this principle or not. In contrast, any violation of civil law is considered a wrong against an individual. So with civil law, it's concerned with private rights and remedies, not necessarily the public good. So, for example, if I get into a car accident because I'm driving too fast and hit another person, I can be held civilly responsible because I've damaged that person in some way. If you look at torts, they fall within civil law and consist of a wrongful act that causes harm to an individual. So furthermore, it's up to the harmed individual, not society, to take action. There's different types of torts. They consist of 4 different legal elements or legal requirements for a violation of civil law to have occurred. Number 1, an individual must owe a duty. Number 2, the duty must have been violated. Thirdly, the violation of the duty must be the proximate cause of the suffered harm. And fourth, the harm that occurred must involve a legally protected right. So for a tort to have occurred in a car accident, for example, that I caused, I must have owed a duty. Generally, it's legally recognized that operators of motor vehicles have a duty or a responsibility not to collide with other drivers, or more generally to obey traffic regulations. For example, I have a responsibility or a duty to turn left only when there is a green light and no oncoming traffic. If I collided with another driver because I turned left while the traffic light was red, I violated or breached the duty. A breach of duty can be intentional or the result of negligence. So when negligence occurs, when an individual falls below an ordinary or reasonable level of care, we call it negligence. So even if I did not intend to turn when the light was red, it may have been negligent of me to do so because of a reasonable person or a reasonable person in this situation would not have turned at that time. The third element of tort is proximate cause. For the third element to be met, my violation of the duty must be the proximate cause to any harm the defendant suffers. So proximate cause is normally considered to be something rather that naturally follows or occurs in an unbroken continuous sequence of events. So, for example, if a giant meteor falls from the sky at the exact moment that I'm turning left at the red light, smashes into the plaintiff's car, and then I collide with the damaged portion of the car, my violation of the traffic regulation is not the proximate cause of his damaged car. The giant meteor falling out of the sky is the proximate cause of this damage, even though I may have met the first two elements of the tort. So, in order for the harm to occur, the opposing driver must suffer damage to his car, be physically or psychologically injured, or suffer some kind of harm. So in this example, I have fulfilled the first three elements of the tort, but instead only bumped the opposing driver on his bumper so that he did not suffer any damage to his car or to his person, rather. A tort would not have occurred because he did not suffer any harm. So civil law generally recognizes that there must be damage because one of the purposes of civil law is to compensate the victim for damage suffered and even to restore him of his proper state, whether that is physically, psychologically, or even financially. Therapeutic jurisprudence has been defined as the use of social science to study the extent to which a legal rule or practice promotes the psychological and physical well-being of the people it affects. Basically, what therapeutic jurisprudence involves is the impact of statutory or case law, but also less formal legal processes that may have the focus on the actions of judges and attorneys. It's spread quite a bit. It's also been applied more generally to suggest any manner in which the law can be therapeutic, helpful in some ways, or anti-therapeutic, detrimental in some. The application of therapeutic jurisprudence does not imply that a particular action must have something to do with psychotherapy or even clinical psychology. It simply means the law can have an impact outside the routine guilt or innocence of a defendant or the negligence of a defendant in a civil case. It suggests that the impact of the law extends beyond the courtroom and can have a profound impact on the practice of forensic psychology in everyday life.